Chapter 9 in Juvenile Justice 8th edition. This is due process and juveniles. This chapter is not quite as long. What's most important in this chapter is the Supreme Court cases that have been passed that impact the criminal justice system, the juvenile justice system. These are important for you to know because they impact what we were talking about, abolishing the juvenile court, giving the juveniles more rights that they deserve, the due process rights, and the right to not uh, receive harsh, cruel, and unusual punishments. But you need to go over these. You need to really review these yourself. I'm just going to go through and tell you the most important parts of each case. You need to know what the decisions were for the cases. Again, just to keep a couple more of the key terms, a couple more of the cases. This is, of course, you just need to review it. It's what you should be able to take away from this. Galt is one of the most important decisions. We actually talked about this in week 1. That a juvenile cannot they have privilege against self-incrimination and the right to assistance of counsel. Remember the boy that was taken in and kept for a long period of time, wasn't able to call his parents, couldn't have an attorney, and then was sentenced. Again, just review these. Okay, we're going to start off with the Kent versus United States. First, just a little background. Juveniles share some, but not all, of the same constitutional rights as adults, because if they did, then we would not need the juvenile justice system. But as we talked about, there's certain rights that adults have that juveniles don't, and one of those is bail, one of those is right to a jury trial. As we saw, there are a few states that have that, but and I need to check on that, but I'm not sure. I think that it's up to the juvenile and their attorney if they want it to be heard by the judge or the jury, because actually that's true now in adult cases. Adults don't have to go to a jury trial. Kent versus United States. Um, Remember, this is where we talked about double jeopardy, where a 16-year-old boy was charged with rape. He was transferred to adult court without a hearing and without the assistance of counsel. And I'm just misspoke. I apologize. This is not the double jeopardy case. This is the Kent versus United States, where the boy was waived to adult court without a hearing. And this case in 1966 said that we can no longer waive a juvenile to adult court without the assistance of counsel, without a hearing, and without any statement of the reasons for the judge's decision to transfer. The court found that the juvenile's Sixth Amendment rights were violated. He did not have the assistance of counsel. He was not allowed access to his case files. Um, and right now, when we were talking about waivers, which we're going to talk a lot more about, there's mandatory waivers, there's prosecutorial waivers, where, and in certain states, if you commit a certain crime, you're automatically waived to adult court. Well, those decisions are in conflict with this Supreme Court case, because if the law states that they're automatically waived to adult court, they do not get a hearing. Gerald Galt, remember we talked about him, 15-year-old, was arrested for allegedly making obscene phone calls to an adult woman. He was adjudicated delinquent in court, sentenced to state training school for 6 years sentence, while the maximum penalty for an adult committing the exact same offense was a $50 fine and 2 months in jail. So here we're seeing a harsher punishment on Galt because he didn't have any rights. The judge didn't have to allow certain things into the court. He wasn't entitled to an attorney, so nobody supported him, and therefore he wasn't entitled to the same rights as an adult. And the main points of the Galt case is that it allowed privilege against self-incrimination in the Sixth Amendment right to counsel. A few years later, we have the Winship case, and this was an appeal of a case involving a 12-year-old boy who stole minor theft. in that the U.S. Constitution at that time required that adult criminals would be found guilty under the standard guilt beyond a reasonable doubt. And at this point, juveniles were not. So Winship ruled that the same applies for juveniles in juvenile court. In McIver versus Pennsylvania, we talked about this, where the Supreme Court ruled against the action for the adult right to a jury trial for juveniles. And if you just read the reasons here, the court did not want to turn the process into the full adversarial process of an adult, which, well, a lot of people are pushing toward now anyway. Jury trials are not an absolute necessity for accurate determinations of delinquency. In other words, they believe that the judge can therefore just determine guilt. And the court was reluctant to impose a federal requirement of a jury trial because such a mandate could prevent individual states from experimenting with different methods. The Supreme Court did not want to tie the hands of the courts because the hope of the Supreme Court is that each state would do what is right for the juveniles in their district, and if they needed to make changes and improvements, they would do so. And remember, even these cases right here on due process, just because the Supreme Court has ruled that way doesn't mean that the courts do that. They have ways of getting around this, but the idea and the philosophy behind it was that that many children were not getting the rights that they were deemed by the Constitution because they were children, and that's not fair under the Constitution. So these cases gave them those such rights. The other rulings that we want to talk about are Graham versus Florida, and this is the rulings on life without parole. And the Supreme Court ruled that a life without parole is unconstitutional, and it violates uh, the the Eighth Amendment and the 14th Amendment of that prohibits cruel and unusual punishment. And this is true except in the case of homicide. And so we mentioned this in class that states cannot make the decision to keep them in prison, that it's supposed to be indeterminate sentencing. Later, we have Miller versus Alabama, where the court banned the mandatory imposition of life without parole. And states can impose the life without parole, but only after every consideration is is considered on an individual basis. And we move to Breed versus Jones. This is the one I was referring to a minute ago on the rulings on the waiver. That before a juvenile is entitled to receive a hearing before they are transferred to adult court, which was Kent versus United States. But Breed versus Jones, in addition to that, says that they cannot receive that hearing and be adjudicated a delinquent and then waived or transferred to adult court. It violates the double jeopardy clause of the Sixth Amendment. On interrogation, these were following a number of adolescents and juveniles being interrogated without parents, with the increase of self-incriminations. So JDB versus North Carolina ruled that courts should consider age as a factor before any interrogation. Of course, leaves the decision in the hands of the police officer. If they feel that that adolescent, excuse me, is that age is not a factor. Oh, they're mature enough to listen and listen to answer my questions, then they can force them to answer questions because the juvenile doesn't know their own rights. But the ABA recommends mandatory attorney consultation, but most states simply stipulate the Miranda warnings, saying, oh, I Mirandaized him, but many times the juvenile doesn't understand that. And as I said, the Supreme Court ruled that many youths don't understand their constitutional rights, and even having many times it's, well, if the parents there, it's okay. Well, if you will watch and listen to cases, many times the parents tell them, go ahead and just tell them the truth. Just tell them what you did so we can go home. And that is the wrong thing to do. They are entitled to an attorney and they don't have to tell the police anything. And there are some additional rules on interrogation. Many states have the totality of the circumstances approach, with a few of the rules requiring juveniles the opportunity to confer with a parent, guardian, attorney, or other interested adult, like a mentor. Pennsylvania Supreme Court ruled that a juvenile can waive their rights, but they have to then talk to the judge, so the judge can therefore decide if they fully understand. And Yarborough Warden versus Alvarado, that's an additional Supreme Court that ruled on the same of questioning and interrogation, that a 17-year-old suspected of murder was involved in an interview without even his Miranda rights being read. And he did not assume he was in custody. And I want to mention something. There's a ruling regarding custody, and uh, it's a misconception. But if you are in police custody, you may not be arrested, and you may not even be suspected, but you may feel that you're in custody. If you feel that you are in custody, then you are obligated to answer their questions. It's kind of a catch-22, and they have to have read you your rights before you can answer any questions. But this comes up a lot where somebody will say, well, I was read my rights, but I didn't know I was in custody. So, and if you are taken into the police station and into a room, you are therefore in police custody. You're not under arrest, but you're in custody. If you question a child, say in a school setting or in a setting outside of the police department, they may not feel they're in custody and may then feel that they can talk openly. Shaw versus Martin is another case regarding interrogation. Now, this case was regarding preventive detention, and preventive detention was defined as when you have a concern over a juvenile that might commit additional crimes, might flee, they might be in danger of additional public safety. At that point, they can be housed in preventive detention awaiting a hearing. The Fourth Amendment issue of search and seizure, which indicates preference for warrants before police search or arrest subjects. But this law under search and seizure requires the police to obtain a warrant before they are permitted to search even your car. Now, there's exceptions to this, because if a police officer feels that they're in danger, or if they have probable cause to search and seize, they can, but it could be thrown out in court later. So many times, unless they've got that probable cause, they cannot search. Now, it's a little bit different when you're addressing consent searches for a juvenile, because a juvenile has to fully understand what that means. And the issue is that a juvenile may not be mature enough to understand what they're asking, or to withstand the pressure that the police are putting on them. And it's the way that a juvenile has that respect for authority. There's another standard under this rule that stipulates that a parent can give consent for those under 16, and that the police are under no obligation they are under no obligation to inform them the right that they can refuse. Now, you have United States versus Mark James Knights in 2002, where the Supreme Court ruled on a warrantless search that it did not violate the Fourth Amendment. And there's another one in 94, obviously before that one, that did the same thing, that the search and seizure of a juvenile did not violate his Fourth Amendment rights. Corporal punishment, which we know what that is. Corporal punishment is when in our school systems where students are allowed to be paddled or to be a victim of corporal punishment. In 1977, the court ruled that a student could be paddled as long as it was reasonable, but the dissenting view on the other justices were very strong in that they argued that if punishments would not be imposed for the commission of crimes, then how can you impose them for less culpable acts during the court system? So many school systems no longer use corporal punishment as a means of correcting delinquent behavior. And the ABA recommends against the use of corporal punishment in schools and students. And like I said, most schools do not use corporal punishment anymore. There have been studies out that receiving corporal punishment is the same as being paddled by your parents, that a juvenile who receives corporal punishment is more prone as an adult to become violent and even commit domestic violence acts. A recent Ninth Circuit case ruled there's no reasonable principle to ever use corporal punishment on a child for doing things such as punching, slapping, grabbing, slamming students in the lockers, being late for school. I can remember when my son was in middle school, and this would have been, let's see, the uh, in the 90s, and he was paddled a number of times, and it was for acting out in class. It was for not for something he could be expelled or suspended, but he could receive, and usually it was a choice. You want to be paddled or you want to go to in-school suspension. So they would get paddled. Another controversial issue within the schools is the freedom of speech for students, and the Supreme Court upheld that students have a First Amendment right to the freedom of speech within their schools. But they did put stipulations. This doesn't mean that a student can cuss out their teachers. It just means that they can express themselves as long as it does not interfere with the school discipline or the process of education. The decision of the Supreme Court came after the Tinker versus Des Moines Independent, where students were suspended for wearing black armbands. And so the Supreme Court then ruled that First Amendment rights had been violated. This has come up before, and more recently, probably within the last 10 years, where students have worn certain shirts to school and they were forbidden from wearing shirts. And so, of course, parents came up with the Freedom of Speech Act that they had a right to express themselves through their clothing. The court also voiced in this case that the concern wasn't so much for children, but we know that children, especially in elementary school, are influenced by their parents, and their clothes are bought by their parents. So parents might be uh, pushing that on their children and interpreting it that, well, we can have our child wear this to school because it's a freedom of speech. And a more recent case in 2007 was the Morse case versus Joseph Frederick, which was in Alaska, where students, and you can read this, where students held up a banner when the Olympic torch went by, and the Supreme Court ruled that when it's a school event, that the school does have the right to limit the free speech, especially on something that's encouraging illegal drug use. And what's interesting, you've probably seen this before because, there's a lot of activities that are prohibited when you go on a school trip. You may be in public, you might even be in a movie theater, but you are prohibited and you have to follow the school rules while you're on that event. Some of the other freedom of speech cases, Bethel School District number 403. In this case, this was actually, the court was looking at kind of the opposite, that what was being said was that the school did not have the constitutional right to limit a student during their speech. This young man used obscene language in a speech, and which violated a school policy, so he was suspended, and Supreme Court upheld that. Some of the other cases that have been heard, Steyer versus Bethlehem, argued that compulsory community service for high school graduation forces a student to engage in expressive contact, and it supports the agency receiving the service. And what this means, and some of these lawsuits a lot of times are frivolous. These students did not want to participate in community service as a requirement for graduation. For instance, I don't know if you've had this in your schools in Knoxville. My kids here in Johnson City, when they attended here before graduation, they had to do community service. And sometimes it was as easy as going through their youth group at church. They would do something as in, clean up somewhere. My daughter, for instance, tutored at one of the schools after her after school, and that could be counted as community service. So it was really, really pretty easy to fulfill. But anyway, the Supreme Court ruled that a part of graduation requirements does not violate the First Amendment. And these next few cases have been very controversial, and they really affect us because at King, because we're private, we do not have to adhere to certain requirements, we can have prayer within our school system. I can conduct a prayer meeting within our classroom anytime I want to, because first of all, we're built upon that. That's part of our mission. But a couple of these cases ruled that the school officials um, erred in providing guidelines when they permitted prayer at high school graduation. And here's another one where the right of the students to plan and lead prayer at school functions. And the degree to which school prayer is allowed even today is kind of yet to be determined. Brown versus Gwinnett County upheld a statute authorizing a moment of quiet reflection, so that they weren't promoting a certain type of religion. New Jersey versus TLO has to do with searching students, searching their lockers and their belongings, and the Supreme Court ruled in '85 that it is constitutional if the search is justified in extent. This means that the student searches are whenever the public officials believe that there are reasonable grounds for suspecting some contraband, even in their locker or their backpack, they have the right to search. A couple more cases: Doe versus Renfro and Safford Unified School District. And the first one here is really interesting because sometimes many times the Supreme Court refuses to hear a case, and a lot of times by not hearing the case, they are allowing a judgment to stand. And in this case is what they did. They allowed a canine unit to conduct general searches when they were looking for contraband, but it did not allow nude body searches, and nude body searches are not permitted at this point. They're not even permitted for juveniles in state custody in Tennessee. They can go down to their underwear, but they are not allowed to be searched down to their skin. A couple more on student searches. Veronia School District, Todd versus Rush. These authorize the use of drug testing, especially for athletes. If they want to participate in an activity when the participation is voluntary, then they could be subject to drug testing. The constitutionality of curfews. Remember, I mentioned this at the beginning. This could be important, but the curfews have been enacted to decrease juvenile crime because there were research that showed that juvenile crime increased between the hours of 12 a.m. and 4 a.m. But some curfew laws are not enacted and they're not followed. But in 1993, this curfew law was challenged and it was ruled that it did not violate equal protection or free association grounds, and therefore it was not unconstitutional. And which is saying that they could therefore use curfew laws. A couple more states: John versus City of Opelousas and Chicago versus Morales. Um, and many times these cases, the reason that they're heard or they're ignored or struck down is it could be just in the wording, and that's what you see on the first one, because it gave an exception to the curfew, but only for emergency errands. And what if a youth or a student is out on a school activity and they have to be out over curfew? Maybe they don't get back quick enough. Again, on Chicago versus Morales, the Supreme Court also struck down this anti-loitering ordinance that prohibited two or more people from loitering for no apparent purposes. This violated the vagueness law, and this is one of those cases. And last week when we were talking about gang control, this is what this was trying to combat, because what the authorities were saying is when they see two or more people loitering in a specific area, that it's probably gang activity, and people were arrested just for standing there. And one thing, let me go back here, um, because as I said before, the reason the curfew laws were enacted because studies were showing that the majority of crime was happening, but research after the curfew laws were enacted showed they did not reduce juvenile crime. And it's funny, it's kind of something funny. When I was a kid, I used to always tell my parents when they'd say you have to be here at 12 o'clock, and I'd say, well, that's okay, because anything that I want to do after 12, I can do before 12. So what's the point of even giving me a curfew? Anyway. legal drinking age, as we said in '84, they passed a law that increased the drinking age to 21. And Mothers Against Drunk Driving, which I'm sure everybody has heard of, is actually successful because they do a lot to against drunk driving, and the fact that you can't purchase alcohol until you're 21 is supposed to reduce the number of accidents by juveniles. And research shows that lowering the drinking age increases alcohol-related collisions with the higher fatality rates for nighttime and single vehicle crashes. The purpose of the laws was because uh, juveniles are too immature. They're just now learning to drive. They're also too immature to be able to control their alcohol. So that's one of the advocates for raising the drinking age to 21. But uh, it did not deter and it did not reduce the the fatality rate. And this is something I was talking about earlier, that the graduated driver licensing laws in many states, you don't get your full license. You know, you have restrictions on it up until you're 18 years old. And you know, it's no surprise, and it won't be for, you know, it's going to continue. There's always going to be those that agree that the drinking age should stay at 21. There's those that believe that it should be dropped down to 88. And this is what I was mentioning the other day in class, is the issue of raising the drinking age is the fairness. You prohibit 18 to 20-year-olds from drinking, but yet we treat them as adults in every other way. They can fight for our country. And other arguments against the high age is it increases the drinking because it's a forbidden fruit. And we should teach them to do it right. And parents can use a lower minimum age as an educational device. And it used to be that you could drink with your parents, you know, they could give you a glass of wine. But now it's really contributing to the delinquency of a minor. If you know, if it's found out that you're giving your any adolescent, any juvenile under 21 alcohol, you can go to jail. And that's the end of chapter 9.